affected in their decision making. So regardless of who's elected as a judge, the fact that these judges are going to have to raise money in order to get themselves elected and re-elected will affect their decision making. And this was, of course, an issue that was before the Supreme Court in the Caperton versus Massey case a couple of years back, involving justice on the West Virginia Supreme Court, where the court said it would violate due process for this judge to decide a case involving the Massey Coal Company, a very powerful interest in West Virginia, given the amount of money that Massey had given to this judge's campaign when he was a judge. So I suppose to transfer this into a question, and maybe let me try to ask one that's more sympathetic to the case for judicial elections. Well, if Caperton versus Massey is the law, can't we control for at least this second type of inappropriate influence by judges recusing themselves from matters in which they benefited from the spending by a wealthy interest group? Should judges be required to recuse themselves in circumstances where they've been the beneficiaries of a lot of campaign cash from either the litigant or the general interest group that is before them in a particular case? I'll give you the first.
Okay. Yeah, I mean, I think the Caperton case is a good first step. It didn't do that much because it was such an extreme amount of money and such a clear conflict of interest that it's not. I'm not sure how well it's going to apply to the everyday kind of campaign cash that we see. I do think this is a problem with judicial elections. I think it's, however, not again a strong argument against abolishing elections altogether for judicial spots. I think there are solutions beyond what Caperton did, which is not really much again. But I do think that Supreme Courts should set rules of disclosure and recusal for judges who are on the bench. Essentially, you have to disclose where your money comes from, and if it's a substantial amount, you can set that amount where you want. Then you have to recuse yourself from deciding a case where that person's a litigant. I think that would probably go as far as we need to go in making it clear, both removing any temptation to rule in one way based on campaign donations, and the appearance of propriety, which is an even bigger problem. There's not much evidence actually that judges are voting differently because of the money they get. People tend to give money obviously to sympathetic justices, but they'll probably vote that way anyway. But there is a lot of evidence that people, both judges and voters, believe that judges change their mind because of the money they get. So I think good disclosure rules and recusal rules are necessary, but are not a dramatic step. And I think those would be controversial, and that's could be something we could do to sort of remove that appearance of propriety.
Professor Huebert.
Yeah, I agree with all that. Very much that.
First, I want to thank the panelists for helping me come to a decision on this issue. I'm thinking about it for weeks. But my question is in regarding to voter competency. We kind of discussed it a little bit in both professors' talks. But we asked voters to elect state and federal candidates that have to decide very complex issues. They have tools such as staff and special interest groups that help them come to a conclusion. I imagined these elected judges also have tools at their disposal to come to a conclusion. You say that the political process dirties, if you will, the ability for them to make these decisions. What is the difference? What is the difference between having a voter elect a judge and having a voter elect a representative?
That's a great question. I think there's 2 points to that, two separate issues. One is, are voters really unqualified, more qualified here than they are in other situations? And the other is, how does it dirty them more to do it as judges, to campaign and so on, and worry about polls that does for legislators? I think the second point is easier for me to make. I think that legislators and governors and presidents and so on, I think their job is, in part, in representative democracy, to follow what the people want, to do what the people tell them to do. Not always. I mean, obviously they can take brave stands against public opinion at times and face the voters, try to explain their actions. But their job is essentially to represent the interests of their voters. That's what they do. They're not doing what judges do. What judges do is they take a law, they take the text of a statute, or they take a case that that's a precedent. They take a constitutional provision and they interpret it based on their expertise. Now, I'm not naive enough to think that they don't have maybe a political bias of some kind that might affect how they interpret it. But I think there's a distinction between what we ask them to do, which is apply your expertise and decide this case based on your individual professional judgment, based on your years of training and education, and based on your extensive knowledge of the law. And what we ask the legislator or governor or an executive to do, which is make a decision based on not just what you think is best based on your expertise, but also what you think the people want you to do. I don't see why judges should, frankly, have to listen to what the people want them to do. I do think, again, we might have a problem of overreaching as with any position of power, which is maybe the only reason to have judicial elections. But I don't see that as something we should worry about when we think about judges. The second point is, though, why are they less qualified to elect judges than, say, other positions? I think just to make your question harder for me, I think voters can understand more or less what legislators and governors and presidents do, and they can get a pretty good grasp of that if they make a minimal effort. And there are big, basic issues of, higher taxes, lower taxes, spending on this, spending on that, whether or not to, how your foreign policy should look, whether to, there are a lot of issues that people can understand pretty well, which I think is not true with why a judge might make a particular decision in a particular case, or a whole pattern of judicial voting over the course of a 6 or 10 year career. I just think the judges apply more expertise and apply a skill set and knowledge base that voters don't have. But I think your question is strong when you're talking about all the other people we do elect. I mean, we elect, in Ohio, we elect the coroner, we elect, sheriff, we elect a bunch of local politicians and frankly, I'm not sure if I know what good that does either. I mean, I see I'm supposed to elect the coroner in the county. How am I supposed to know who the best coroner is? I think that's a little silly. So my answer is twofold. I think that when we elect people that actually make policy that are political in nature, I think that's absolutely what voters should do. When we elect people that have that are essentially applying, that should be enslaved in politics, applying a skill or expertise of some kind, I'm not sure the voters' input is useful in that situation.
You kind of already have my views on this from what I said. I think voters can vote according to judge, not maybe on a case-by-case basis, but certainly on the basis of that judge's judicial philosophy. I think that's something that people can understand. I think people can understand, for example, whether the Constitution, like at the federal level, contains a right to abortion or not. Your judicial philosophy is you think we should read new rights into the Constitution based on changing views and so forth over time, and you might think it belongs there. If you think we should just stick to the text, you probably would have trouble seeing it there. And I don't think you need any special legal training to understand a lot of that stuff. I think more and more you see a lot of people educating themselves about the Constitution and thinking about judicial philosophy. And I think people can make some judgments on that basis, at least as well as they can on this other stuff. But again, I don't think voters are particularly well qualified to decide our economic policies or foreign policy or anything else because they make bad judgments all the time. But I would still rather have them choose than coordinated special interest choose. And that's the real choice here. And that's what the proponents of appointment don't address. The fact that it's not perfect or voters who do all this bad, crazy stuff and don't know anything. It's special interests getting to choose, or voters at least having a chance of maybe having some outside influence having a say in there.
So let me ask a follow-up question on voter information. Right? I think Professor Huebert is probably right that even if you're like me and think that this is the worst idea ever to elect judges or subject them to retention elections, we're probably stuck with it. It's not likely that voters are going to take away their own right to vote for judges. If that's the case, shouldn't we at least provide them with more information than we do here in Ohio? We actually nominate the judges who appeared on your ballot last Tuesday on a partisan basis. They are the nominees of their party. Now, if you go to the Columbus Dispatch website, you can find out which party nominated which of the candidates. But if you don't do that, you don't know that information. So isn't that the worst of all possible worlds? We have party-affiliated judges in this state, but we deprive voters, or we don't at least make it readily available, as we do for all other offices, of the information regarding what party those judicial candidates are affiliated with. If we're going to have judicial elections, shouldn't we at least disclose this information to voters? Professor Huebert.
Yeah, I agree completely. I think that is valuable information. Professor Simmons seemed to suggest that maybe party affiliation doesn't convey useful information or isn't that useful. But I think it's very useful. I mean, I think rank and file Republicans and Democrats know the difference between Republican and Democrat judges generally. It's why who's president matters so much, because of Supreme Court appointments. Everybody understands this. Everybody understands what's at stake. They know the Republicans generally favor one set of judicial views, and Democrats generally favor some slightly different one. And sure, there are outliers. There are people who take different views on particular issues. But as a basic proxy, party affiliation is a very good piece of information. And so, yeah, it absolutely should be on the general election ballot. And unfortunately, new Chief Justice O'Connor has suggested taking away the party label at the primary level too, which would just be horrible, because then voters would have no clue at any stage what any of this is about. And so, yeah, the more information, including more party information, the more judges can say their judicial views, the better.
I would absolutely agree with that as well. I think, well, most of it. I do think party affiliation is a pretty weak indicator. I'll still stick to that, but it certainly is an indicator of some kind. It's better than no information at all. So I think we should have party affiliation, and certainly have better and have encouraged more information about judicial candidates. Again, I built a website trying to do that with mixed results. But also, I think that judges candidates should be allowed to go out and explain their views, explain what decisions they made and what they might do with the future. I guess the only place where I sort of break rank with that is the idea that party affiliation is that useful. I think it's better than nothing. But if you look at, certainly look at the history of Supreme Court nominees that were confirmed that didn't act like the Republican or Democratic president that appointed them thought they would act. I think it's even less of a good indicator for the hundreds of judges we elect for a municipal court judge or a common pleas judge. These are judges that essentially they're not being political at all in almost any way that you can think of. They're making rules on evidence, they're making suppression hearing rules, they're following laws given to them by the appellate courts, by the Supreme Court, and so I'm not sure how party affiliation helps you in that situation. More information is always good, but I don't think that's going to tell you if someone's the kind of judge you like or not for those hundreds of lower court elections.
I should add that you may be right about that. Most of my arguments do pertain to the high court. Lower courts, I think there's a lot more room for debate over how we would choose those. But so most of what I'm saying is for high courts when they actually do decide policy questions.
So what about getting a sense out to the general public about particular judicial candidates, political philosophy? Sort of, what do you think does the election mechanism and a candidate stumping or putting out advertisements get as clear of a picture of a candidate's judicial philosophy out versus the confirmation process and the candidate being forced to defend their views on whichever subject and answering questions from a panel of people who we hope ostensibly have some idea of the questions they're asking?
Well, I think they're both really bad, right? I mean, these nomination hearings are pretty useless because they just say they don't know anything, they never thought about anything. Yeah, they're just going to apply the law as it is, sure. So, I mean, neither one of them is very good. So, I think certainly we should think of innovative ways to get the information out. And third parties who have an interest in doing that, perhaps because they want to promote candidates who support their philosophy, may have an incentive to do that. But there's certainly a lot of room for improvement with both. And it's hard to say whether one's better than the other.
I'd agree on a couple of points. One is that the confirmation process also is particularly unhelpful, really. It's also not as good as elections, I think, because you have to say it happens before you put on the bench. At least with elections, if it's a protection election, you're running for re-election, you have a record that voters can see, okay, you did these things, explain yourself. Why did you vote this way in the eminent domain case? Why did you let out this person who went on and raped and killed somebody? And you have a chance to sort of explain that decisions you made, voters can sort of at least evaluate that to some extent. But I do think there's a better method. I do think that there's not just political philosophy that matters for judges. I do think that this sort of a panel of experts that they have in the Missouri planning exam